Happy Sunday, everybody. Gonna talk trust today. The last live I did, people seem to really like, I guess, the way we were going through some information, kind of walking through some things. Trusts, a lot of people don't really understand what trusts are. I remember when I first heard the word trust, it was like Bigfoot, like talked about but never seen. I had no idea what a trust was or did or how it functioned, or and it really is a mythical creature until you really start to learn about trust. So I figured today would be nice to introduce everybody in the group to some trust basics. And in introducing trust basics, it is important, and I always say that the way I study is it's very important to go to the definition first, usually the legal definition, right? Because we're talking about legal things here. When we're talking about trusts and law and things like that, we want to go to how the law views these things. I use, a lot of times I use Black's Law Dictionary, 4th, 6th edition. I'll use all the editions, really, if I want to look and see the differences in some of the definitions and things like that. I'll go online and use a legal dictionary online and things like that. But I want to go over some trust basics today and why trusts are important. And, let's dispel some of these myths of trusts, or misinformation, or just in our own minds, let's clarify, what trusts actually do and what they are. So trusts function a variety of ways. They can be simple or they can be complex. Complex trusts function like a corporation almost. The trust itself is almost like the bylaws, right? It's the indenture. Okay, so let's put that aside so we don't get too deep too fast. But let's read the Black's 4th version, okay, of the definition of trust. All right, so in general, now this is a general definition. All right, in general, a right of property, real or personal. Remember, real property is land, my flesh and blood, anything attached to the land, houses, trees, things like that. Okay, personal property is pretty much everything else. All right, chattels are like paper property, immovable things. Okay, okay, so a right of property, real or personal, held by one party for the benefit of another. It's that simple. That is a trust. Okay, if I go over to Sam and I say, Sam, hold this car. This is my car. I want you to hold this car for Johnny. Okay, and don't give it to Johnny until Johnny has done A, B, C, or reached, this age. Okay, but I need you to hold it, Sam, and I need you to take care of it. And while you're at it, I need you to do the upgrades on it. I just established a trust. It didn't have to be written. I gave him property to hold for the benefit of Johnny. Now, if I said, Sam, I give you this property to hold for Johnny, okay, to use, all right, and you to use it, but I'm going to pick it back up in 3 years, and I want you to make sure that everything is, right and tight on it, all the maintenance has been done and all that. That's a bailment, because I'm giving them the property held in trust that I am going to then pick up at a later time. Okay, and they both get the benefit out of this. So that's a mutual bailment. That's not a trust. That's property held in trust. Doesn't mean it's a trust. Okay, so there's a difference when people say something is held in trust and when an actual trust arises. All right, so you want to be conscious of that too. So that's the basic definition. And of course, the definition goes in further. A confidence reposed in one person who is termed trustee for the benefit of another, who is called the cestui trust, respecting property which is held by the trustee for the benefit of the cestui trust. Cestui trust just simply means a beneficiary. It's a trust where there's a beneficiary. There's property held for a beneficiary. That's all cestui means, okay? A lot of these people going around the Sestakey Trust, Sestakey Trust. I mean, yeah, sure, there's a Sestakey Trust there, absolutely, but it doesn't. That's not the only trust we call a Sestakey. You know, any trust that has a beneficiary essentially is a Sestakey. So let's read the definition of Sestakey Trust. All right, Sestakey Trust: the person for whose benefit a trust is created, or who is to enjoy the income or the avails of it. So, if a trust was created between me and Sam to hold the car for Johnny, Johnny is the Sestakey because he's the beneficiary. It's really that simple. Now, constructive trust, let's look at that one because this is a good one. A trust raised by construction of law or arising by operation of law, as distinguished from an express trust. So what I just described to you was a trust that arose by operation of law because there's nothing express, nothing was written. That's all express means, is written. We didn't express it, but because of the actions of the parties, me giving the car to Sam and Sam holding it for Johnny, a trust was created. Now that's not a constructive trust, that's an implied trust, or it is in fact a trust when the parties perform the actions. But let's read further about a constructive trust, because I found this to be interesting years ago when I came across it. Wherever the circumstances of a transaction are such that the person who takes the legal estate in property cannot also enjoy the beneficial interest without necessarily violating some established principles of equity, the court will immediately raise a constructive trust and fasten it upon the conscience of the legal owner so as to convert him into a trustee for the parties who in equity are entitled to the beneficial enjoyment. Now, if you didn't follow that, we're going to go back through that because everybody talking about court, and fighting your court cases and doing all this stuff, you're missing the point, okay? It is a constructive trust when you go in there. And they are flipping the role and making you the trustee so that the trust can be established and then holding you liable. Okay, so let's read this again. Wherever the circumstances of a transaction are such that a person who takes the legal estate in property cannot also enjoy the beneficial interest without necessarily violating some established principle of equity. All right, so let's pick that apart. Where the circumstances of a transaction, what transaction might we be dealing with if we went into a court situation? We might be dealing with the original transaction of the probate of the estate back at birth. Okay, that's a transaction, whether you like it or not. It's a transaction, okay? And as such, the person who takes the legal estate in property, all right, cannot also enjoy the beneficial interest. So who has taken the estate in property but cannot enjoy the beneficial interest without violating some established principle of equity? Okay? The state. They can't enjoy the beneficial interest of the trust. They can't do it unless, let's go back into this. Let's read that again. A transaction are such that the person who takes the legal estate, in property cannot also enjoy the beneficial interest without necessarily violating some established principle of equity. Let's just pretend that was the state or the court, right? Then the court, well, really the state, because the state's the one that brings charges and things like that, right? Okay, where'd it go? The court will immediately raise a constructive trust and fasten it upon the conscience of the legal owner. Who's the legal owner? Who's the legal owner? Answer that question. You. So as to convert him into a trustee for the parties who in equity are entitled to the beneficial enjoyment. So it will convert you into a trustee so that the parties can enjoy the benefits, because they can't enjoy the benefits until you become the trustee. Okay, so that's a problem. That's a problem. Okay, which is why claiming that estate, that trust, which we'll go over in a minute, is very important, not because you're going to become a trustee of that trust, because you're going to become an executor of the estate for which or to which the trust belongs. Okay, now that gets a little twisty. So when we were born, okay, evidence of a living man came out, and the certificate of live birth certifies a living man. It's got the landmarks, the estate footprints, okay, bam, created a fictional piece of land, okay, put your footprints on it. Then a trust was created. This is why I say to people, there's no trust created at birth. And of course, people flip shit. No, there's not a trust created at birth. It's created after birth, upon the new birth of the fiction, which is the file date of the certificate of live birth, which usually happens anywhere from days to weeks to months later. Okay, that's when the trust is created. When the Social Security account is created, that's where the trust is. Okay, that Social Security account is the trust. That's the property. That's everything held in trust. All right, so if you come as in the office of general executor, you now have the authority to appoint them in a constructive trust to settle the matter of the estate. And that's where I say I don't deal with all of that statutory bullshit. No, because there's already a claim, okay? There's already a claim on the estate. So that's first. Hold on. Before any movement happens, we have to determine who has a right to the estate and who has a right to administrate it and appoint administration for it. And this is why I say if you don't make your claim, anything else you do, because you're coming from a defensive standpoint during an attack, you don't have an offense because you didn't create one. What football team, what athletic team, any sport goes out onto the field without an offense? Which one? None. Which is why when people come to me and they go, oh, I got this problem, I got that problem, and I go, well, did you correct your status? Did you make your claim? Oh, I didn't do any of that, but I need to do it now. Well, that's a little too late, man. You know, I mean, you can't build an offense for a defense when you're having to defend, you're already being attacked. Like, it's a little too late. You know, that's the point. And after the fact, if you don't create a claim or an interest in the estate and take back the estate, and you do get attacked, you can't go backwards. You can't go backwards. They're not going to accept that. So you have to set yourself up prior to any incident. And it's not about living in private and being private is not about the paperwork. And it's not about setting up your offense. It's about how you conduct your business from that point forward, from the point of the claim and the point that you claim to be private forward. Because any step into the public a specific way, by implication, by operation of law, you're public, you're not private. So it doesn't matter how much private paperwork you've done. If you operate in a way that you're public, then you're public. You can't mix public and private. And Yusuf El does a great job at breaking down which law is public and which law is private. It's pretty cut and dry, you know. So anyway, let's get back to trust. So from the basic trust of giving property to someone as a trustee to hold for someone else's benefit, there's all kinds of different variations of it. There's a revocable, an irrevocable, a statutory, a non-statutory, which would be a private trust, right? There's so many different names. Don't get caught up in the names. What determines what a trust is the construction of the trust. You know, so an irrevocable trust is when you put property into a trust that you have no right to take back out. A revocable trust is a trust where you put property into it, and you have a right to take it out at some point, okay, as the grantor. An irrevocable trust, once you put it in there, it's irrevocable. You can't pull it out, okay? Now, there are grantor trusts where you have a grantor. The grantor would be me in the case of giving Sam the car for Johnny, because I would be granting the car to the trust. for Johnny's use, okay, or a settlor, or I would be settling. Now, there are also trusts that are contracts before they're trusts. So there isn't a grantor and there isn't a settlor. There's a creator, but there's not a grantor and a settlor. What happens in a trust situation, when I gave that car to Sam for Johnny, what I did was I gave Sam legal title over that car, okay? But Johnny retains the equitable title as the beneficiary, okay? So he's got an equitable right to that property, but he doesn't have a legal right or title to it. He doesn't have a receipt for the property and legal title because the trustee has that. The title is basically like a receipt. Now, if you have an irrevocable trust and it is set up in such a way where you exchange that trust for a certificate of interest, okay, you are giving both legal and equitable title to the trustee. You have no you have no equitable title. However, you have a beneficial interest and a certificate to show that. That's a powerful construct if you understand how this stuff works, okay? But let's not get into, all the detail of it right now, because I'm hoping people that aren't familiar with trust can kind of see that this trust thing is not so, magical. It's really quite simple, okay? How you construct the trust and how complex you make it is where a lot of the protection comes in with a piece of property that you're placing into the trust, okay? So with that said, there is all this talk all over the internet about a trust that's created at birth, which a few minutes ago I just said, no, it's not created at birth, it's created after birth. I've got proof of that all day long. I don't need to prove that to anyone. That is a fact. So what happens in that situation is, again, there's a trust created, okay, in the name of the estate, right? And that's property. So let's answer the question, what is estate? People don't even understand what an estate is. They think it's a house on the hill with everything that you own, or the house that you own, and but it's not just the house. The estate is any piece of property that you have a claim to or on. Wouldn't you say your body is your property? Wouldn't that be an estate? It is to me. I know I've claimed it. All of everything that you'll ever own is part of the estate. The estate is simply another way to describe estate is simply a sum of all of the property that you have ever owned. But here's the thing. You don't own any property, especially if you bought it with the Social Security number attached, because it's not your property. It's not your property. It's the person's property. It's your person. It's your legal person's property. A lot of us understand how that works, right? It's the trust's property, especially if it's bought attached to the Social Security number. It just makes sense that if that's held in trust, anything attached to that is part of that trust, okay? So courts are merely administrating the trust through you. They're getting you to do it all, and they're holding you liable for it, all right? Which is why years ago, when I would go into court with someone, I'd say, no, they're the beneficiary. They're not the trustee. They deny trusteeship right now. We're going to cut that, nip that in the bud. We're just going to talk about the trust here. And of course, the whole courtroom would empty. Please have a seat. They'd empty the whole courtroom, call them back up. I mean, they do it every time because that is how it's really functioning, So getting into trust, once you are private, how do you protect things? How do you own things? Well, you don't own them. You don't want to own them. Ownership is liability. And if your trust is constructed properly, you can control what it owns without having the liability. But there are certain criteria that needs to be met. Because if your trust is ever called into question and you have to defend it, you're going to have to know what that criteria is and how that trust is constructed in order to defend it. Okay? The IRS, they'll look at your trust and they'll put it through a test. Same thing with your church or ministry. If you've got a 508 set up, if you've got a 508 set up, 508c1a, you better have that thing set up right, because they will put it through a 14-point test. They get a hold of it, And if it fails, they're going to hold you liable, straw man, not straw man, whatever, unless you really know your shit, you know? So again, a lot of this boils down to knowing the moving pieces. We have the main root of everything that's going on right at our fingertips. But everybody keeps getting lost in all this hocus pocus over here. Statute, code, I'm going to sue them. I'm going to hold them to the letter of their law. I'm going to do this. I'm going to do that. You don't even have a right to do that. You're not the owner of the trust, and you'll never be the trustee. Well, you'll be the trustee. You don't want to be the trustee. Okay, you want to be the beneficiary of the trust, and you want to have the power of attorney to administrate or appoint others to administrate that trust for the benefit of the cestui. You know, that's where all the power comes from. In my experience, everything I've done has been on these principles across the board. I do not veer off of these principles. It's God first, then it's trust, right? Or sorry, God, estate, trust. You know, think about that. Get it? GET, God, estate, trust. You know, I'm a child of God. I'm a creation of the Creator. There's no claim higher than that. Then I come in and claim the vessel, the body, as the estate. Okay, and I go, I'm claiming the estate, and I'm going to put it into trust. And all the trusts and accounts attached to it that were created without my conscious knowledge at the time, right? Bam. And that's how I operate, okay? And I'm not afraid to put that out there. I mean, that's how I operate. You know, everybody else has their own way of doing it. That's all good. To me, everybody says, oh man, it should be simpler. It should be simpler. Well, to me, it doesn't get much simpler. Okay, but it's never going to be easy. It might be simple to comprehend or simple to put together, but it's not easy. I get that. You know, so if you're looking for easy and, oh, I shouldn't have to do this or I shouldn't have to do that, what that tells me is you're looking for irresponsibility. So you don't have to take responsibility and actually put time in and do something. You're still waiting for a handout. Well, that's what the government's for. They're there to hand you out whatever the hell it is that you're saying you're too lazy to do. Not a problem. Keep taking the benefit. He who enjoys the benefits ought to bear the burden, you know. So this is why, in my opinion, trusts are very important, because they are, in fact, a very good mechanism for protection of property, estates, assets, things like that. The statutory trusts, I disagree with most of them. Whenever I see a trust where someone is a trustee and a beneficiary, that to me, it just makes me laugh. I'm like, why would you be a beneficiary and a trustee at the same time? How can you even do that? So you're telling me you're holding legal and equitable title at the same time? Why have a trust? I mean, you're doing that anyway. When you go out and buy something, you're holding both legal and equitable title without a trust. So what kind of trust is it if you are holding both legal and equitable title as the trustee and the beneficiary? It makes no sense. But in statutory world, everything is reversed. Everything is reversed. So it makes sense in that context, right? Because everything's reversed. So that's why I look at statutory trusts and I laugh. Now, I've also seen Massachusetts trusts, a business trust, common law trusts, they're all the same, okay, that were not administrated and properly operated. And so, you know, there's plenty of court cases where they've broken right through those trusts because of the way they were managed, not because of the strength of the trust, because the people, the trustees, the beneficiaries, the managers, the protectors, all those people, well, not really a protector, but all the people involved, the employees of the trust, whomever of the business trust, were not functioning properly, okay? And they formed a partnership essentially by their actions. That's what's called operation of law, okay? Operation of law is action. You don't need a contract, okay? All these people, oh, you need a contract, you need a contract, you need a contract. No, you don't. Your action forms the contract. That's why they say, oh, a contract could be, you know, verbal or oral. It's not even verbal or oral, it's your actions. You know, somebody comes to your house and they put, milk at your door and they go, hey, we're offering this milk. If you go ahead and, use that milk from us, you owe us $10 for the week. If not, let us know. We'll come back and pick it up. Well, you take the milk off the doorstep and you drink it. They can now take you to court and sue you. You just formed a contract. But if you said, hey, no, take your milk back, I don't want anything to do with it, no contract, because you clearly disagreed to the terms and conditions. That's a contract that arises out of operation of law. It's the same thing with a credit card. People go, oh, I need to see the original contract. The courts laugh at that. They're like, what are you talking about? Clearly, you used the account, right? Clearly, you used the account. That's a contract. So that's why they laugh at it. However, if you know what you're doing, there's much more to a credit card transaction than just the contract, okay? And yes, we know that they're bogus shit and it's all a bunch of crap. But at the same time, I'm telling you how the courts look at it. How do I know? Because I've seen literally hundreds of these cases. Hundreds, okay? So where people go, oh, I need to see the contract, I need it in a quick. What are you talking about? The contract's right there. Okay, so one of the keys in that situation is prima facie evidence of contract, right? And accuracy of accounting. Why accuracy? Let's talk about that for a minute while we're on the subject of trust. So in a credit card transaction, a credit card issue, why is it important, or why would the accounting and the accuracy of the accounting be so important? Because it's a trust. You don't own the account. You never own the account. You're the holder of the account. So what do we call somebody that holds property? We just went over this. I'm sure y'all can answer it. You get an A if you answer it. It's a trustee. So you're the trustee, and you're saying, oh, wait a minute, as the holder, I don't approve of this accounting. I need to see the accounting on this because the numbers are off. Okay, I need a certified copy of the accounting. I'm the holder of the account here. That's right. There's a credit card contract. See it? Yep, right here, prima facie evidence. All right, it's got the estate name on it. That must mean I'm the holder. That's a powerful position to take. So anyway, but why? Because again, when you're holding something, you're basically a trustee. All right, because the bank is benefiting off of that. When they charge their interest and all that stuff, they're benefiting. And they're saying, hey, we have interest. We have beneficial interest in that account you're holding. Hello, it's right there all the time. The trust is everywhere. So it behooves us to learn about trust, even if we're not going to use a trust, which I wouldn't do that. That's not my suggestion. I would suggest that everybody has trust set up. But when you look around you, you see that, that's how most of this is functioning, okay, with trust. Now, when you bring in the higher trust, the trust from the Lord, or God, or Supreme Creator, or Allah, or whoever you want to call it, it's not a man, it's not a woman. Obviously, it created man and woman and female and male, so it's got to be both. But anyway, when you bring that trust in, level the field, man. Bring that trust in. I am holding this vessel in trust for the Lord. I am here as a steward of the earth. I can't own anything. Not sure what's going on here. There's an estate created. Here's the record of the estate. The birth certificate. It's a clear evidence of the estate, and it's certified. I mean, that's the other thing. A lot of people don't realize what they're actually saying with a birth certificate. You're saying, look, an event took place right here. An event took place. A living, natural person, a human being, a man, a woman, whatever you want to call it, arrived on this earth, and then this birth certificate is evidence that there's property created for them. They bailed over the property to the state. The state has held on to it. You never claimed it. It's basically a coat sitting at the coat rack waiting for you to go pick it up at the cleaners. It's just sitting there, So that's, once you do that, the ball game changes. But it doesn't change just by recording your documents and just by doing a UCC1 and just by, some sort of writing. It doesn't change until you actually learn how to operate. That's where the change comes in. And there are records that I suggest canceling. If you've ever paid an income tax, you've formed a contract, you're going to want to revoke that election. That's my opinion. Again, I'm not giving you tax advice. I'm just saying if you have not revoked election and you're thinking about canceling contracts, that's one contract I would cancel. I don't know if people are commenting, but if you are, I'm not getting any of them here, so I don't know what's going on the Facebook. Of course, we know they do all kinds of shit. Other contracts, correcting the SS5, the Social Security, correcting the passport, those types of things. When you correct the SS5, and if you correct the SS5 properly, all those will be changed anyway. Okay, so the key is going through the Social Security, and I know that for a fact. Okay, I haven't done it yet for various reasons, but I'm getting ready to when the time's right, because I already know people that are doing it, have done it, and it's definitely viable. And all your IDs will change, so you don't need to worry about the driver's license, the passport, the this and that, because it's all coded with a different designation. And we've got confirmation of that. So, but again, you still want to operate in trust. You still want property held in trust. You don't want anybody attacking the trust. And if they do, you want to have a solid fortress. That's why it's important. That's why your status is important. A lot of these people want to go in and change the system. I'm going to go in and change things. I'm going to, make that county do this and make that judge do this. And those of you that have done that know that they are corrupt as the day is long, and they are going to fight you tooth and nail. But unless you have some sort of standing, they're going to run right over you all the time. Even with standing, they're going to try to run all over you. So, you better establish your standing first, and that is made through declaration, other steps. But anyway, I don't want to get too far into that because we're talking about trust, or at least basic trust law. So in trust has to have 4 main properties. Some of you people probably heard me go over this before. Okay, and this comes out of collegiate text, law text. This is not just Rob throwing Wikipedia out there. You need parties, property, purpose, and intent. As long as those 4 attributes are there, that's a valid trust. Parties, property, purpose, and intent. Okay, so that forms the basic trust. And then we talked about the scenario, if I give a car to someone and they hold it, the intention is there, the purpose is to hold it for Johnny's use. The property is the car, and the parties are me, Johnny, and Sam. Okay, so there you go. You got the parties, the property, the purpose, and intent. So that is some very brief trust basics. I hope for people that are new to this, that are going, what is a trust? What do I do with a trust? I don't understand a trust. I don't know. I hope that kind of clears some stuff up. It's not as complicated as you think. It really isn't. It's just that you don't know anything about it. That's like when you first saw a bicycle. You didn't know how to ride it. You looked and went, I don't know, man. It looks easy. I've heard about it. I'm going to try it. But it took you a little bit to, get your bearings straight and stay up. But once you stayed up, you can ride it forever. It's the same thing with learning this stuff. Once you learn it, you can do it forever. And you get better at it. So just keep researching. But don't lose sight of the basic facts when you're talking about your status, and civil law. Civil law, and we're not going to get into common law and all that at the moment. We're going to talk about, real quick, I've said this in the past couple lives, there are 3 departments to civil law, 3 distinct departments. Okay, one is the law of status, the law of property, and the law of obligation, which is contract. That's it. So all the millions of statutes that govern, that are under civil law and all that, fit into one of those categories. Where's the obligation? Who owns the property? What's my status? What property are we talking about? What obligation? How did the obligation arise? You know, what is my status? Who am I? State citizen, federal citizen, non-citizen, American national, you know, which I don't agree with the American national designation, by the way. There's a reason for that. However, you know, what's the other one? There's non-resident alien. You know, certain statuses take hold at certain times, okay? So, but you have to know what your status is to begin with to switch hats. This is all about switching hats. Remember, this whole entire thing is created on acting, right? That's why there's an act. Congress did an act. They put on a play. Woo, we did an act. And as long as everybody consents and believes the act, then they're all part of the play. Better wear the right hat, right? Take your hat off, put the next one on, the next one, and the next one. You're just switching hats. But if you don't know the hats and how they function, yes, you're going to have trouble navigating. Keep it simple. They all boil down to those three departments of civil law. Now, when you get into criminal law, you'll notice, you'll look up criminal law in your dictionary. I believe they even have quasi-criminal, okay, in the dictionary here. I could be wrong, but we're going to look because it's been a while. Okay, quasi-criminal means it's not criminal at all, actually. Let's see if they got it in. Ooh, crime. Look at a big section on crime. Ooh, yeah, they got all kinds of stuff. Love it. All right, crime, statutory, high crimes, infamous, statutory crimes. Those created by statutes, as distinguished from such as are known to or cognizable by the common law. Interesting stuff. All right, let's see. Criminal. Do we have quasi-criminal? Criminal act. No. Let's see. I'll just see if I can find it in here. If they even have it. It might be under another section. But anyway, quasi-criminal. That just simply means it's not really criminal. It just has the appearance of criminal. So in essence, it's civil, right? That's where you get quasi-criminal. So again, even in a quasi-criminal, when there's no injured party, no one's been injured physically or their property, you turn around and you go, okay, we're really in civil law, even though it looks like criminal. What are the three departments of civil law? Do I have status and standing? Status and standing, same thing, relatively. Do I have the right to the obligation? Do I have the upper hand in the obligation? Is there an obligation? Okay, and whose property is being administrated? Do I have a claim to that? Do I have a right to the property? Am I the one with the power to administrate or appoint administrators to that property? Those are the three fundamental questions. If you're trying to build some sort of defense and you can't answer those three questions, or you don't even start with those three questions, you're probably going to be in a world of shit, okay? And you're gonna spend a lot of time beating yourself in the head with these guys and a lot of stress that you really probably don't need, you know? I wonder if it's under Q. I'm gonna be Q. And, you know, this just for some reason is bothering me, and I want to see if it's actually in here. Because I know I have looked it up. I just can't remember what volume, and all my other volumes are on the computer. I don't see any quasi-criminal, but what I do see is quasi. As if. Almost as it were. Analogous to. This term is used in legal phraseology to indicate that one subject resembles another, okay, with which it is compared in certain characteristics, but that there are intrinsic and material differences between them. It is often prefixed to English words implying near appearance or want of reality. There you have it. Pretty simple. That's quasi. So just put criminal on the end, and there you go. You got your definition. Okay. So, again, you know, all boiling back to trust, man. All of it. So I hope everybody got something out of that and is able to, you know, see what trusts really are and how much they're used, because they're everywhere around you. They're used everywhere. They're used against you. Seldom are they used for you, unless you actually create one yourself. So yeah, that's why the richest people in the world use some powerful trusts, because they understand the legal construct and where the power in the trust lies. Now, especially if you're putting a trust under ecclesiastic principles or spiritual principles, it's got a lot of power, man. And if it's set up correctly, okay, it does have a lot of power. So anyway, I hope you guys got something out of that. I know some people have worked with me on trusts, and they're really happy. Very thankful. Good people. Y'all are good people. All you guys, man, that comment and, send me emails and stuff. You guys are awesome. Just keep it up. I mean, the more each one of us does in our own lives helps the collective. You guys will probably never see half of the things I've done, but I do know that, yes, while they may be to correct what I'm doing, they're also correcting the collective. So that's why it's important that you do your thing, man. And, don't let anybody tell you you don't know what you're talking about and that's crazy and this and that, that's just their own fear. So, there's no trust in fear. So anyway, all right, guys, I'm going to go. I got things to do. I hope you all enjoy your Sunday, and we will catch up soon.